Further hearing in the appeal Jones against Birmingham City Council and another.
Just before the Broadfoot speaks, may I just check that you received a note from me?
Yes, we have.
Yes,
Thank you.
Thank you.
Ms. Broadfoot.
Yes, good morning. Could I check as well that you've received an updated supplementary authorities?
5 additional authorities.
Yes, I think that's right. Yes, but they've been put on the bottom of the additional authorities bundle filed yesterday so that the page numbering all works if you click on it electronically. So hopefully you've got that.
I hadn't registered that.
Yes, this is one that includes, for example, Schenk and Switzerland. Is that the right?
So, yes, it does include Schenk and Switzerland, but it's the new one if it also includes as the Criminal Justice Act 2003, McCann in the Court of Appeal, Osborne, Ringwald, and SAP.
No.
There's one that was posted this morning at 8:20.
That's it. It's
on our files.
That's the one, my lord.
Bundle updated supplementary authorities.
Yes.
Oh, I see.
It was meant to go to our SharePoint. I'll just see if it's there.
One
Yes.
I've got that's called Updated Supplementary Authorities has 8 authorities on it.
It's got 367 pages.
Yes.
Yeah, I'm sorry, I don't seem to have that. Is it on SharePoint?
My lord, I understand what's happened. When you look in the outline section electronically, it only goes to 8 items. But if you actually click on the actual index at the front, you should see that the index runs down to 13. But because of the pressure of time, the additional authority titles, although the index is clickable, the additional authority titles didn't make themselves.
Yes, on page 2 there are 13 authorities.
Yes, that's fine, thank you.
Which bundle are we?
It's updated supplementary. If you, it's quite it's near the top of the list.
Yeah, it was. This got this morning's date on it.
Yes, 31st of January.
Ah, okay, yes. Sorry, I'm being slow here. Thank you.
Thank you. So I'll only be referring to 2 bundles, the original, obviously, the original bundles and this one. Following on from the hearing yesterday, I'm asked to address you on 2 issues. One, any Strasbourg cases on the standard of proof, and secondly, whether McCann should be understood as an authority on Article 6.1 insofar as the standard of proof is concerned. Turning first then to the Strasbourg authorities on the standard of proof, the first point is that the starting point, we say, is the general principle which the European Court has repeatedly made, that the admissibility of evidence and the way it should be assessed are matters primarily for regulation by national law. That principle is not in dispute between the parties, and you were taken to Mantovanelli yesterday. But in fact, the more traditional citation for that proposition is Garcia Ruiz against Spain, which is a 1999 Grand Chamber decision. In the main bundle, electronic page number 2805. The relevant paragraph sorry, I'm now, give me a moment. This was a civil case concerning a dispute between two individuals and where one was seeking payment from the other for services said to have been provided. There was a dispute about that. The applicant lost the case, he appealed, and the appeal court dismissed the appeal in fairly succinct terms. The issue at the heart of it related to the adequacy of reasons that were given, because the complaint was that the appeal court had violated his Article 6(1) right to a fair hearing because they had not addressed his arguments. That's paragraph 19 of the judgment. On page 2811. And the court held at page 2813 that judgment should give adequate reasons, paragraph 26, but the extent depends on the nature of the decisions and the circumstances of the case. Appeal courts can simply endorse the reasons below. And then the relevant paragraph for the general principle is at paragraph 28 on page 2813. Insofar as the applicant's complaint may be understood to concern assessment of the evidence and the result of proceedings before domestic courts, the court reiterates that, according to Article 19, its duties to ensure the observance of the engagement undertaken by the contracting parties to the Convention. In particular, it's not its function to do with errors of fact or law allegedly committed by a national court unless and insofar as they've infringed rights and freedoms protected by the Convention. Moreover, while Article 6 guarantees right to a fair hearing, it does not lay down any rules on the admissibility of evidence or the way it should be assessed, which are therefore primarily matters for regulation by national law and national courts. And it cites Schenk in Switzerland. That is a case establishing exactly the same point, but in the criminal context. My second point is...
Do you say that the way it should be assessed, you say that it covers standard of proof or not?
Not always. They have subsequently specifically included standard of proof as a separate addition to that general statement. So, which was bringing me on to my second point, which is that this general statement has now expressly been held to include the standard of proof. And the case for that is BKAS against Germany. And that is at page 2980 of the main bundle.
I think that's Falk in the Netherlands.
Oh, I'm sorry. Have I given you the wrong reference?
2980.
Oh, I'm sorry. I've taken it down wrongly.
No.
2980.
Yeah.
Now, BKAS is a criminal case. The facts were that Mr. BKAS was charged in Germany with coercion to engage in sexual activity in at least 300 cases, and with sexual coercion in another 18. That's at paragraph 7 on page 2982. The victim was P, a young woman suffering from what's said to be a moderate mental disorder and an autistic and speech disorder. That's paragraph 10. And then paragraph 8, jumping back slightly. After hearing 17 days of evidence, the trial court issued a decision in accordance with German criminal procedure limiting the prosecution to charges concerning 4 incidents which had taken place in a 1-week period in August 2007. And you can see from the middle of that paragraph that the court then provisionally discontinued the proceedings in respect of all the other offences the applicant had been charged with. And the applicant was further informed that if he was convicted, the court could take into account findings made in respect of the other incidents when setting his sentence. At paragraph 12, paragraph 11, the regional court, the regional court explained, paragraph 11, that it had restricted the conviction to the 4 events between those specific dates. It had discontinued the proceedings in respect of the at least 300 further charges, but was convinced that in at least 50 cases there had been incidents comparable to the 4 of which the applicant was formally convicted. It had simply been impossible, they said, to determine their exact time and place due to the victim's speech disorder. And these additional incidents were then treated as an aggravating feature for the purpose of sentence. The complaint is at paragraph 25 on page 2988. The applicant complained, paragraph 25, that the regional court had violated the presumption of innocence when determining his penalty, as it had taken into account as an aggravating element sexual offences of which he had not been found guilty as the proceedings against him for those offences had been discontinued.
So was there a separate complaint under Article 6.1, or is it all just about Article 6.2?
No, it was just all about Article 6.2. And so the question was whether, paragraph 51, paragraph 51 on page 2994, the second half of it, the court, so the Strasbourg court finds that the impugned statements, i.e. those of the regional court, which said that they were convinced that in addition to the 4 incidents, the 50 similar incidents occurred as well, clearly show that the regional court found the applicant guilty of having forced P to engage in sexual activity on the further occasions. It appears that this is in fact uncontested between the parties. And then the important part in my submission starts at 58 on page 2995. The court considers that in these circumstances, the applicant was found guilty in substance also of the 50 further offences to which a different standard of proof was applied. That standard of proof was sufficient under domestic law for taking these offences into account in the sentencing process, but not for formally convicting the applicant thereof. 59, the court observes that the standard of proof necessary for finding a person guilty of an offence is for the national authorities to determine. The court therefore considers that the applicant in the present case was proved guilty in accordance with the standards which were and could be fixed by domestic law, and also of the 50 further incidents in question. And so the point of this authority is twofold. Is one, that the court has clearly found that the standard of proof is a matter for the national authorities. I mean, I would accept within limits and of the requirements of presumption of innocence, etc., obviously, but it's nonetheless a matter for the national authorities. And then secondly, they had no difficulty at all with the system in Germany in which different standards of proof were applied to different sorts of conviction.
Different sorts of conviction.
Yes, so he was formally convicted of the 4 incidents within a specific week period.
But when sentencing, the German court took account of the fact that there were 50 other offences without formally convicting him of them. Is that?
That's right. But for the purposes of Article 6, the court held, and it wasn't in dispute, that those findings upon which the sentence was aggravated amounted to, in effect, a guilty, a finding of guilt. So it was a matter
So for the purpose of actually convicting him, the presumption of innocence did require, or the higher standard, or at least the higher standard was applied, but for the purpose of taking them into consideration for sentencing, they seem to be satisfied with a lower standard.
Well, the truth is that in both cases, the court says the standards were high was high in both cases, and actually, because taking them into account for the purposes of sentence, the presumption of innocence also applied. But they, because these were 6-2, they found that these were 6-2 matters.
But I mean, it seems to be significant that they're only taken into account, the 50 further incidents are only taken into account for the purposes of sentencing rather than formal conviction. Yeah. Because if one reads on to paragraph 60, they're saying, well, if there was going to be a formal conviction, then there would be an issue under Article 6.2.
Well, that might be because it's a kind of double jeopardy thing, that if they're...
Yeah, I think that's right. I mean, in a sense, that process is so alien to our domestic system that it's hard to translate into things that make perfect sense within our legal context, which is why the authority is relied on was simply for the point at paragraph 59 that the standard of proof necessary for finding a person guilty of an offence is for the national authorities to determine.
It rather looks from paragraph 56 as though there's a requirement under German law that a conviction specify the time and place of the offence. And that could be, that was done in relation to the 4 incidents of which the applicant was convicted. You know, while for the first 4 incidents the court had all elements to define the crimes, for the other 50, it couldn't indicate the exact time and place at which the incidents took place because of the speech disorder, and so those proceedings were discontinued, but the 50 incidents were taken into account in sentence as they were satisfied that, what does it say, they were convinced, yes, it was convinced the accused was guilty. So whereas in this country one might have, it would be a certain latitude in relation to convictions of offences in those circumstances. There may be the rather stricter approach taken in Germany, which prevented a conviction of more than 4, but nonetheless permitted the other 50 to be taken into account in the sentence.
My Lord, I think that's right, because actually earlier on in the judgment, 2 passages that I didn't take you to, there's a discussion of the German rules on treating those offences separately and not as a continuous series of events, etc. So I think that's right.
But in 56, they do actually say that the occurrence of the acts had been proven beyond reasonable doubt.
Yeah.
Yes.
So it doesn't seem that they're endorsing a lower standard of proof in respect of the other 50, even for this more limited purpose.
I mean, at the beginning of 56, the court says visual court can accordingly be said to have applied pursuant to domestic law high but different standards of proof for the determination of the applicant's guilt in respect of these incidents.
It's not so much the standard as precisely what has to be proved in the way of particulars.
It sounds as though the dictum in the first sentence of paragraph 59 is really what you need to rely on, rather than the particular the facts of the case.
Yes.
The dictum may be wider than the facts required.
And this is not the only case where a dictum to that effect has been made.
That's what I want to say about that case. The third point is that a more recent case, which is in now the supplementary bundles, relatively more recent because BCAS was 2018. This is 2019. More recent case called SA Capital OI against Finland. In our submission, makes it clear that Article 6 does not mandate any particular standard of proof, even in criminal proceedings, and held that the standard of proof applied was not arbitrary.
What page is it?
And so that's in the updated supplementary bundle at 328.
Thank you.
Let me just... Now, this is a competition case. The case arises from proceedings concerning restrictions of competition brought by the Finnish Market Authority. Paragraph 5 sets out the background, but in summary, it was brought by the Market Authority and conducted against several companies operating in the asphalt sector in Finland and accused of having operated a nationwide cartel involving price fixing by means of territorial allocation of markets, bid rigging and other restrictive practices in public and private sector contracts. At paragraph 6, there's a summary at the bottom that the applicant complains under Article 6, alleging that in the proceedings between the Supreme Administrative Court, which I'll explain the hierarchy in a minute, the latter relied on hearsay evidence, which the applicant was not able to have cross-examined. The applicant also alleges that the standard of proof applied by the Supreme Administrative Court was contrary to 6.1 and that the burden of proof had been shifted onto it in violation of 6.2.
Sorry, which paragraph is it?
That's paragraph 6.
Thank you.
At paragraph 11 on page 332, under the heading of the competition law proceedings, paragraph 11 effectively summarises the position, which is that the Market Court found that the applicant company had taken part in a cartel in respect of asphalt contracts commissioned by the central government authorities, by participating in territorial allocation markets, by participating to a minor degree in price fixing activities, etc. A penalty payment was imposed of €75,000. And then with regard to the allegation of territorial allocation price fixing in the markets for local government and private sector asphalt contracts, the market court found that the applicant company had not participated in our cartel. And then paragraphs 12 and 13 basically go on to explain how the market court viewed the relevant market for the purposes of the proceedings. The market authority disagreed with the analysis of the market court and appealed, and this is paragraph 16 on page 333, appealed to the appeal court, which was called the Supreme Administrative Court. And at paragraph 16, you can see that they were appealing regarding the scope of the restricted practices, that it was nationwide and encompassed the entire market. And there were cross appeals from the companies, including the applicant company. There was an issue about hearsay evidence, with the market authority saying it should have been taken into account, and Capital Oy saying it should be excluded. Paragraph 18 shows that the Supreme Administrative Court overturned the Market Court's decision, having heard from a further 6 witnesses and having also taken into account hearsay evidence amongst others. That's paragraph 18 and 20. And the applicant company's fine was increased to €500,000. And at paragraph 20, at the bottom of 334, the Strasbourg Court summarises that the Supreme Administrative Court made a number of general statements about the assessment of evidence in competition proceedings, and these are all set out at 21 to 22, paragraphs 21 to 22. And there were further compensation proceedings, but I don't need to trouble you with that.
In 21, we see the standard of proof applied by the Supreme Administrative Court.
Yes.
It's firm conviction.
Well,
at least that's how they express themselves.
You'll see that what we might think is firm. Yes, that's the translation of the standard that they apply, but you'll see that shortly that it doesn't mean beyond reasonable doubt, for example.
No, that's why I was paying attention to it.
Oh, I see.
Well, it's a different way of expressing it.
Yes.
At any rate.
So the complaint to Strasbourg was in 2 parts. Page 343. There was an allegation, there was the alleged violation of Articles 6.1 and 3 of the Convention. And you can see at paragraph 55 what the complaint was, and it is effectively focused on a hearsay point.
From unidentified sources?
Yes. What happened was that witnesses came and they were called and cross-examined, but they were unable to identify the source of, it wasn't direct evidence. And the court, so insofar as that part of the judgment is concerned, it's not of direct relevance. The relevant part, let me just go to it. So
What was the second issue, the relevant
The second issue was a violation of 6.1 and 6.2, and that complaint is on page 355. Yes, it's paragraph 98 it starts. The applicant company also complained that the Supreme Administrative Court had accepted that in competition law cases the standard of proof could be lower than beyond reasonable doubt, or, as in the present case, lower than the preponderance of evidence standards. It further complained about the shifting of the burden of proof. And then the analysis is at, you'll note at paragraph 103 that the government's position was that the domestic legislation did not prescribe any standard of evidence, nor were there any formal provisions on the allocation of burden of proof applicable in administrative judicial procedures.
Sorry, this is paragraph
103.
Thank you.
And the court's assessment starts at 106. The court reiterates that, as a general rule, it is for the national courts to assess the evidence before them, to apply the relevant standard of proof, and to evaluate whether the admitted evidence is sufficient for a conviction. Fairness with regard to criminal proceedings also includes respecting the presumption of innocence. These were treated as criminal proceedings, as falling within 6.2. Article 6.2 requires, inter alia, that when carrying out their duties, the members of the court should not start with a preconceived idea that the accused has committed the offence. The burden of proof is on the prosecution. Any doubt should benefit the accused. Therefore, the presumption of innocence will be infringed if the burden of proof is shifted. And then 108, again, a general principle won't be of any surprise here, and is reflected indeed in our criminal procedure. And then 109, in the present case, the court notes that in its judgment, the Supreme Administrative Court discussed the questions concerning the burden of proof and the applicable standard of proof. See paragraphs 21 to 22 above. About halfway, a third of the way down, the same paragraph, in light of the Supreme Administrative Court's judgment, the court cannot find any indication that the principles adopted in it or their application conflicted with the requirements arising out of 6.2, nor is there any indication that the Supreme Administrative Court has a preconceived idea of the applicant company having been in breach of the competition rules. In these circumstances, it cannot be said that the Supreme Administrative Court shifted the burden of proof to the applicant company, nor is there any indication, the case file, that the standard of proof applied by the Supreme Administrative Court was in any way arbitrary, and that these complaints were therefore manifestly ill-founded.
So what do you take from this case?
It is a clear statement that matters of standard and indeed burden within certain confines are primarily a matter for domestic law. And it's clear from the different factual matrices that we've just seen that obviously lots of different countries have different approaches to these matters, and they've never laid down any formulation or requirement for one standard of proof over another, be it in criminal proceedings, which is obviously subject to greater restriction, or in civil proceedings.
I wonder whether that really is right, because at paragraph 107 in the court's assessment, you get reference to the Barbera case,
Yes.
which is sort of the classic statement that any doubt should benefit the accused. And in the paragraph you were showing us, the reference back was to review of what the Supreme Administrative Court had done when it discussed questions of burden of proof and applicable standards. And it's referenced back to paragraphs 21 to 22, but that's where, as Lord Reid pointed out, the Supreme Administrative Court concluded that it had a firm conviction of the relevant offence having been committed. I'm just not sure that this is helping on or is supporting the proposition that you're putting it for, that a state can have any standard of proof that it likes.
No, I'm not suggesting that state can have any standard of proof, because obviously in the context of criminal proceedings, it is restricted by the presumption of innocence and what that means. Take the Barbera case. So I accept that. My point is that it's not laying down any particular formulation, provided the presumption of innocence is respected.
Well, does the presumption of innocence then require, as paragraph 107 seems to suggest, that reasonable doubt, that there is a proof beyond reasonable doubt? The presumption of innocence will be infringed where the burden of proof is shifted from the prosecution to the defence. The burden of proof is on the prosecution. Any doubt should benefit the accused. Is that another way of saying beyond reasonable doubt?
Well, that is how the language works in English, but the reality is that people say things like, I have to be convinced, we need to have moral conviction, but none of these lay down a specific standard or a specific, they lay down a high standard where the benefit of the doubt must be given to an individual, but they don't lay down a specific formulation one way or another.
Isn't it just a different way of expressing the same test? Firmly convinced is there is no doubt.
I mean, I see that.
I'm not sure I would concede the point very readily. You can look. I mean, the French don't have books on the law of evidence. There is no such subject as a law of evidence, and the idea of a sort of analytical distinction between a burden of proof and standard of proof, for example, I think is alien to them.
Well, we've set out in our written case reference to articles that try and look at standards of proof in various jurisdictions, and in our case, and it is in our Anglo-centric, through our Anglo-centric prism, some of this is quite hard to understand. It's in our written case at...
Well, see, I noticed perhaps it's helpful in paragraph 73, the court reiterates the general principles that Article 6, that admissibility of evidence is for national law. As a general rule, assessment of evidence is for domestic courts. Thus, the court won't, in principle, intervene in issues concerning assessment of evidence unless, and the proviso is, unless the decisions reached by the domestic courts appear arbitrary or manifestly unreasonable, and provided the proceedings as a whole were fair. Now, that language is then picked up at the end, at paragraph 109, when they come to the conclusion that there was nothing arbitrary in the in the approach adopted by the Swedish courts.
Yes, my lord, that's right. In fact, actually, there are general principles set out from paragraph 66 on page 346. Which emphasise from in 66 the requirement of a fair balance between the parties. At 67, that the rights deriving from the principles are not absolute. Even in criminal cases, 4 lines down on 67, the court has held there may be competing interests which must be weighed against the rights of the party to proceedings. However, only measures restricting the rights of a party to the proceedings which do not affect the very essence of those rights are permissible under 6.1. For that to be the case, any difficulties must be sufficiently counterbalanced. And then they go on to explain that in the court's case law, the autonomous interpretation of the notion of a criminal charge has led to a gradual broadening of the scope of the criminal aim of Article 6. Emphasising, I think, a point that my Lord Reid made yesterday about fairness not being just a feeling, but actually containing constituent parts, such as the adversarial principle or reasoning. In the middle of paragraph 69 on page 347, the various rights of which a non-exhaustive list appears in paragraph 3 reflect certain aspects of the notion of a fair trial, exemplifying requirements. They are not aims in themselves. Their intrinsic aim is always to contribute to ensuring fairness of the criminal proceedings as a whole. And then at 70, in this assessment, the court will, inter alia, look at the way in which the evidence was obtained, taking into account the rights of the defence, but also the interests of the public and the victims in seeing crimes properly prosecuted, and where necessary, the rights of witnesses. So,
and the Supreme, one sees in paragraph 22 that the Supreme Administrative Court had rejected a test of proof beyond reasonable doubt on the basis that it wasn't practical in the context of competition cases, notwithstanding that they might be characterised as criminal.
That's right.
And they cite an EU case in support of that proposition.
Well, there's quite a lot of EU case law in this area as to what presumptions arise, because because of this particular difficulties point. So there's quite a lot of competition jurisprudence about this kind of thing.
Mm-hmm. And they reached a conclusion at 23 that it's sufficient that the evidence established with reasonable certainty, that's to do with the period of the infringement, had to be established with reasonable certainty.
Yes, I mean there is a whole section about the difficulties in obtaining evidence in a competition law which the Strasbourg court accepts. So in my submission, they're not certainly in the competition law context, no doubt for the reasons suggested by Lady Rose. They're not saying that the approach of the Finnish Supreme Administrative Court was a breach of Article 6, having applied a different, or the standard of proof that it did. And there may be a reason why there aren't many cases specifically on the standard of proof, indeed any cases specifically on the standard of proof in relation to civil proceedings, and that's because of the variation of the approach across different contracting states, and that the focus of any such cases as that there are about tend to be about criminal proceedings because of the additional constraints placed upon it by Articles 6, 2 and 3. Now, it's perhaps trite and again not in dispute that contracting states have greater latitude over the concept of a fair hearing in civil proceedings than they do in criminal proceedings, and the authority for that is Dombo Beheer against the Netherlands. That is at the main bundle, page 2760 at 2776. The question was whether each party had been afforded a reasonable opportunity to present his case, including his evidence, under conditions that did not place him at a substantial disadvantage. So, but the proposition that I rely on it for is that contracting states have a greater latitude over the concept of a fair hearing in civil proceedings than in criminal.
So that's paragraph
32.
Yes. Then a separate strand of Strasbourg proceedings relate to civil proceedings which are brought after a defendant has been acquitted of a criminal act which underlie the civil proceedings. And the main case on that issue is Ringwald, although I accept that there's also been a sort of diversion in the case law where dealing with circumstances where the civil proceedings are in fact casting doubt on the validity of an acquittal. So setting those aside, which don't apply here at all because there's been no criminal proceedings whatsoever, if one goes to Ringwald, which is at in the supplementary authorities bundle at 308, the facts were allegations of sexual abuse against a child, G. The charges were brought, he was tried, he was acquitted, and there's a procedure in Norway in which civil compensation can be applied for. In light of the acquittal, the court dismissed the application for civil compensation. At paragraph 13 on page 312, G, so the victims, subsequently appealed to the Supreme Court under the rules of the Code against the refusal to award compensation. The Supreme Court then ordered the taking of all evidence. Evidence was taken, during which time more than 20 witnesses were heard. And paragraph 16, the Supreme Court examined the case under the rules of civil procedure. And still paragraph 16, ordered the applicant to pay compensation of 75,000 kroner for non-pecuniary damage. Paragraph 19 the court summarised in the middle of that paragraph that the judge in the Supreme Court, Justice Jolstad, found that the evidence satisfied the standard of proof establishing that sexual abuse had occurred, and that on the balance of probabilities it was clear that the applicant was the abuser. Accordingly, there was a basis for awarding the victim compensation. The complaint was at 26, which was that the applicant complained that the Supreme Court judgment awarding compensation had entailed a violation of his right under 6(2) to be presumed innocent until proven guilty of the commission of the offence. And that was on the basis that he maintained, this is paragraph 29, during the compensation following his acquittal, that he had still been charged with a criminal offence within the autonomous sense of 6(2). The Supreme Court disagreed, and you can see that just above paragraph 31. They stated that, considered as a whole, the evidence had satisfied the standard of proof for establishing sexual abuse had occurred on the balance of probabilities. It was clear he committed those acts. His assessment had, so this is the complaint. This is the way the complainant frames the complaint.
Sorry, you're reading paragraph?
Sorry, paragraph 30. These are the submissions from the applicant. So the complaint was that the finding effectively amounted to a violation of the presumption of innocence.
Is that because he'd been acquitted?
Yes, he had been acquitted, yeah. And there's case law to
He's
show...
not concerned with a civil claim de novo, not connected to a criminal.
Well, actually, the court found that this was not connected, because you're absolutely right that there is this line of case law that where there are where the unifying factor seems to be that where there's a direct connection with the criminal proceedings, that then actually it does fall within Article 6(2).
Yes.
So you're right, and in fact they distinguished. So this case said, well, actually it's not such a case, and you can see from the facts that they heard evidence and they reached their own conclusions about it.
So the court is treating this as a civil claim,
Yes.
Detached from the prior criminal, the acquittal on the criminal charge.
Correct. Yes.
So it would be in our jurisdiction a difference between a civil claim and a claim to the Criminal Injuries Compensation Board, or something, which would depend on there being a conviction, presumably.
Yes, that's right. But the point, so there's quite a lot that's all about classification, and that starts at paragraph 36. And you'll see at the bottom of page 321, the court says, at the bottom of page 321, in the view of the court, the fact that an act may give rise to a civil compensation claim under the law of tort is also covered by the objective constitutive elements of a criminal offence cannot, notwithstanding its gravity, provide a sufficient ground for regarding the person allegedly responsible for that act in the context of a tort case as being charged with a criminal offence. Nor can the fact that evidence from the criminal trial is used to determine the civil law consequences of that act warrant such a characterisation. Otherwise, as rightly pointed out by the government, 6(2) would give the criminal acquittal the undesirable effect of preempting the victim's possibilities of claiming compensation under the civil law of tort, entailing an arbitrary and disproportionate limitation on his or her right of access to a court under 6(1). This, again, could give the person who was acquitted of a criminal offence but would be considered liable according to the civil burden of proof the undue advantage of avoiding any responsibility for his actions, and on the contrary, in a significant number of contracting states, an acquittal does not preclude the establishment of civil liability in relation to the same facts. And then over the page, thus the court considers that while exoneration from criminal liability ought to stand in the compensation proceedings. It should not preclude the establishment of civil liability to pay compensation arising out of the same facts on the basis of a less strict burden of proof. Now, they say burden there, but I think perhaps they actually mean standard. And so they find that at 40, against this background, the court does not find that the compensation claim amounted to the bringing of another criminal charge against the applicant in respect of his acquittal. And so the point is, we submit that even where there's been, so even where the civil claim is predicated on facts giving rise to a criminal conduct in respect of which a person has been acquitted, there's no breach. There's no breach of Article 6 in applying the lower civil standard of proof.
I mean, more specifically, Article 6.2 is just not engaged in that sort of situation. So whatever you get from Article 6.2 in terms of standard of proof is not applicable if it's civil proceedings.
That's right. And it's relevant because a lot of what is set out in the appellant's case is to really try and focus on that a lot of behaviour in respect of which a gang injunction might be sought is likely to be criminal. And my point is that if civil proceedings can be brought even when you've been acquitted of those criminal proceedings, it must obviously follow that where no criminal proceedings are brought at all, there's provided that the matter being dealt with is civil proceedings, which is not in contention, it must be perfectly proper to apply the civil standard of proof.
What this case doesn't say is that the court, the Strasbourg court, is not concerned with the standard of proof in civil cases, which I had really understood you to be citing this for. It just doesn't really touch on that. I mean, it says that it's on the balance of probabilities because that's the standard that the Norwegian court applied, but it doesn't go further and say, well, this is of no concern to us. Perhaps unlike one or two of the other cases you've cited in your...
That's true. It predates it by quite a long time. It's 2003 case, I think, 2003 case. And in a sense, the fact that it doesn't say that the standard of proof in civil proceedings is effectively a matter for domestic courts doesn't matter because the standard of proof being applied in those proceedings is the same as ours.
Yes, but I mean, I don't think it's any part of the appellant's case before us that if there were a civil claim for damages for a criminal act, rape or whatever it might be,
yes,
that the convention would require that to be proved beyond a reasonable doubt. In other words, English law is precisely the same, really, as here. And I don't think any suggestion is made that isn't the case. It's what I think the appellant rely on is the combination of the gravity of the allegation with the consequences in the shape of the restrictions and so on that are contained in injunctions made under the statutes with which we're concerned.
Yes, I think, yes, my lord. But the point that we are seeking to rely on is that once you get into civil proceedings, yes, you can apply a standard of proof such as the civil standard of proof, and this was an example of it, even where the activity underlying the civil proceedings is criminal, and so we would say that there is an analogy there.
I mean, you cite in your written case the case of Thiemann and France and Germany.
Yes.
Now, that doesn't expressly refer to the standard of proof, but it does refer to the burden of proof.
It does.
And says that the court isn't concerned with that under Article 6.1.
That's right.
If the court isn't concerned under Article 6.1 with the burden of proof, it's hardly likely to be concerned with the standard of proof, one would have thought.
Yes, I mean, I can certainly take
Well, you quote the relevant sentence.
Yes, that's.
You refer to it in
right.
the same place as BCAS, but
Yes,
as you
that's
say,
right.
BCAS is a criminal case.
Well, I was trying to focus on standard of proof because that of what was said last night.
Yes.
But yeah, that's right.
So, is there any case in which the court has said that in an Article 6.1 case, a civil case, I mean, to which therefore only Article 6.1 applies, the court is not, or Article 6.1 is not concerned with standard of proof?
No, there's no case that says Article 6 is not concerned with 6.1 is not concerned with standard of proof. But my submission is that the reasoning is because it doesn't actually arise because the general principle which is set out in Ruiz and Mantonovelli yesterday and all these cases is that because matters of admissibility evidence assessment are for national courts, and I would suggest that generally these issues of standards of proof are treated in civil context, are treated under that sort of general umbrella. And so there's been no need to go into specifically what standard was required. And the last case on this that might actually just be an example of it was the case of Saliba against Malta, which you were taken to yesterday, which was in some ways, an odd case. It's at page number 2950. And the facts were that a robbery had taken place in the home of Mr. and Mrs. Z in 1995. The intruders were hooded, apparently, and the couple were kept face down. They were interviewed by the police at the time, and they said they'd not recognised anyone, and no one was charged. But the applicant and his brother had undertaken work for that family as a plumber and an electrician, and that relationship broke down in 1996 because Mr. Z refused to pay his bills. He was sued, so the applicant sued Mr. Z for unpaid bills and was successful. So the relevance of this is to do with motive. And the applicant alleged that during that time, Mr. Z, who was being sued for the unpaid bills, started to badmouth him to neighbours and started to suggest that the applicant had been involved in the robbery in his house, bearing in mind that at the time the police investigated, they said they didn't recognise anybody. And 5 years after the robbery, Mr. Z brought proceedings for damage resulting from the robbery. And he said, in retrospect, that he thought he did recognise one of the robbers as the applicant. Now, following a hearing in the first instance court, the first instance court decided that A had taken part in the robbery and ordered him to pay damages yet to be quantified, and that's paragraph 16, page reference 2958, and an appeal was dismissed on the basis that lower court was entitled to reach the views it did, and there were separate constitutional redress procedures which also failed. The complaint, though, is at paragraph 48, page 2965. It starts, so he makes a complaint about manifest unreasonableness of the domestic courts and makes complaints about contradictory evidence, etc. And then at 51, he says there's a breach of the relevant procedural safeguards, including a failure to apply an adequate standard of proof, as he puts it, at paragraph 51, and then makes other complaints about failure to respect the equality of arms principle and other points. Now, the court does descend into the detail of the case, and it sets out general principles at paragraph 62. The general principle that it's not its function to deal with errors of fact or law allegedly committed. They will not intervene unless the decisions reached by the domestic courts, paragraph 62, appear arbitrary or manifestly unreasonable, and provided that the proceedings as a whole were fair as required by Article 6.1. And just pausing there, they did interfere on the basis that the decisions reached by the domestic courts were arbitrary and manifestly unreasonable. That's the basis they did actually get involved. And then you can see at 64, whilst acknowledging the domestic judicial authority's prerogative to decide what's relevant, 6.1 places the tribunal on duty to conduct a proper examination. And then you were asked, you were taken to 67 yesterday by Miss Mountfield, relating to the difference between civil and criminal proceedings and the greater latitude. And the last sentence, however, the court considers it necessary when examining whether proceedings fall within civil law aspect of criminal. The court considers it necessary when examining proceedings that fall within the civil law aspect of Article 6 to draw inspiration from its approach to criminal matters. And I think my Lord Hodge asked yesterday, well, what does that mean? And the answer to that is, in fact, at paragraph 70, which was that the court considers that even had the first instance court considered that the other evidence to be incoherent, unreliable or immaterial, a comment or explanation to that effect would have been warranted. The court reiterates that in a criminal context, inconsistencies between evidence give rise to serious grounds for challenging the credibility. So that's the point that was what they were drawing inspiration from the criminal context for. It was about the care in which the evidence was examined, not the standard of proof to be applied. And I think, just jumping back, I would respectfully agree with Lord Reid's suggestion that paragraph 64 effectively is the core of the decision. A duty to conduct a proper examination of the submissions, arguments and evidence adduced, and the bottom of that page, an error of law or fact by the National Court which is so evident as to be characterised as a manifest error, that is to say, an error no reason.
So where's the reference to manifest error?
Sorry, page 2791, the paragraph
2971.
Sorry, 2971.
Paragraph 64.
Paragraph 64.
You say the case is really about an arbitrary or unreasonable decision because of a failure properly to assess the evidence.
Yes. And the complaint was that they applied the wrong standard of proof, but the reason why the application succeeded was effectively because the decision was totally irrational. And you can see at 72 that they say in the last sentence, it is indeed disconcerting to imagine that the only objective evidence before the domestic court, namely that the applicant had had access to the victim's house, fulfilled the required balance of probabilities. So the reason why the application was successful was because the decision was manifestly erroneous, to use their language, but they had, again, they say nothing about what the standard of proof is required, in civil proceedings, despite the point being raised. And so my point really is that the court tends to look at Article 6 complaints through the gateway of specific points separately from what exactly the standard of proof is in any given case.
So it looks as though the domestic court had applied a balance of probabilities test, as indeed one might expect in Malta, and the Strasbourg court was saying in paragraph 72 that the evidence received was manifestly incapable of satisfying that standard.
Yeah.
They didn't pass comment on whether that standard was required or not required.
That's right. So unless there are any other questions about standard of proof and Strasbourg, those are my submissions on it.
Just on that, I would have thought that there must be some limits. You know, if you said that one's, had some sort of rule that said that one side will always win provided they put forward any evidence at all, that might
Well, it would
be
probably
thought to offend against
the equality
some
of
notion
arms, or the equality of arms principle,
Right.
potentially, or the
Right, but I mean, yes, I agree. I mean, but equality of arms is a function of fairness under Article 6.1,
Yes.
isn't it? So one might think that there were some limits, but I think you can say, whatever they are, we're a long way away from reaching those limits in our case.
yes, yes.
All right, thank you.
The second point was about McCann, which we say is not authority for the proposition that Article 6 demands the criminal standard of proof in these types of cases. I've got 3 key points on it, which I'll say first and then show you. The first is that point wasn't in issue and wasn't argued. The second is, and that's in relation to the written and oral submissions. The second is that the judgment itself does not in any way suggest that anyone was arguing that Article 6 required the criminal standard. And the third reason is that none of the cases that you would expect to be cited in this field were. At the least, you would expect to see reference to Schenk and Switzerland and Brewers and Spain, and the other cases predating Ringwald, and the type of argument that's been had in this court. And as the fourth reason, actually, I said there were three, but actually there were four. There's no suggestion in the Court of Appeal judgment or in the Divisional Court judgment that this point was being made either. So in relation, and I could perhaps give you the references, is that you've got the statement of facts and issues in both Clingham and McCann. The statement of facts and issues in McCann is at 3593, where the issues are set out at 3595. And the whole focus of the case was on classification.
3955.
The issues were set out 3595.
Sorry, 3595.
35.
Bottom of the page.
Have I got that wrong? Actually.
Whether the application for an antisocial behaviour order under section
Issues.
1
Yeah.
constitutes proceedings for a criminal cause.
That's right.
Can we just get the page here?
Yes, the page 3595.
Thank you.
There's classification as criminal cause or matter in domestic law, and then 3596, whether it's proceedings for the determination of a criminal charge under Article 6.
Yes, so it's classification.
Entitling the petitioners to the protections of 6.2 and 6.3.
Yes. So that's the SFI in McCann. The SFI in Clingham also does not raise this point. That is at 3630, with the issues at 3632. Sorry? I can't hear you. 3633. 3633. Yes. Yes, and Ms. Mountfield's asked you to look at, obviously, the fifth issue in the list, which is on page 3633.
That's a hearsay evidence.
Yes. So McCann was primarily about classification, in fact, was entirely about classification, and Clingham was about classification and hearsay evidence and jurisdiction, because, of course, there was an issue about whether or not the House of Lords even had jurisdiction to hear it.
I think they held that they didn't.
They didn't, that's exactly right. They held that they didn't. The written case in McCann, as you might expect, is all about classification, and the reference is at 3597. I mean, there's no need to turn it up and read it. You know, Ms. Mountford will say if I'm wrong, obviously, but the Chief Constable responds in similar terms, and the Chief Constable's written case is at 3615.
I'm sorry, I didn't quite pick up, or I certainly hadn't picked up the point that was exchanged between yourself and Lady Rose a moment ago. Are you saying that in McCann, the House of Lords held they had no jurisdiction?
No, in Clingham.
Oh, in Clingham.
In Clingham.
Oh, right, thank you.
So I've given you the references for the written cases in McCann from the appellant, from the McCanns and from the Chief Constable. The written cases in Mr. Clingham's case is at 3634. And it too is, as you would expect, focused on the issues in the case until it gets to 3650. when it makes, at the bottom of page 3650, it makes a somewhat confused submission, I would say, about quasi-criminal matters, in Article 6.1, saying at 4.1.1, even if it is held that the proceedings are properly characterised as civil, the appellant is entitled to a fair hearing in accordance with 6.1. Well, we don't disagree with that. Point 2, in determining what is fair in this context, an almost quasi-criminal approach should be adopted, not only in relation to the standard of proof, as recognised in the cases of McCann, B and elsewhere, but in the interpretation of wider procedural issues, and goes on to say, in the circumstances that would, you'd need to look at the requirements of 6.3, and then it deals with standard of proof separately, and the complaint there is a point picked up by your lordships yesterday, which is that as it stood at the end of the Court of Appeal hearing, there was a view that the appropriate standard, that's the middle of 4.2.1, the appropriate standard can be determined on a case-by-case basis. This is an unsatisfactory approach in relation to the appropriate standard of proof. It would lead to lack of clarity and certainty, which in turn is likely to cause injustice, etc. And so they say, as a result, it's submitted the proper interpretation is that the appropriate standard to be applied is the criminal one. And then 4.22, the need for more than a bare civil standard in matters not necessarily characterised for all purposes criminal is being recognised in relation to a number of different authorities, and then cites Bater and Bater, Hornell and Bramblevale, none of which are Article 6 cases. So that is...
Well, at 431 does seem to raise the point, though.
Yeah, that's
contended that such a quasi-criminal approach should be applied in this case in safeguarding the appellant's ECHR Article 6 rights, even if only under Article 6.1.
You're right. You're right. It does raise it there. But then, when you look at then the response. The respondent's written case is at 3660. At page 3684, paragraph 39. At 39, there you have the response from the respondent, which that the point does not properly arise on this appeal, but the civil standards should apply, although except the more serious allegation, the court would need to be satisfied by the evidence, which is a formulation that leads back to B and Avon. And all of this is reflected, as you might hope, in the report of the case, which is in the bundle at 598 to 99.
Sorry, reference.
So in McCann itself, the report of the case is at 598 to 99.
It can be the...
598 to 599.
Oh, I see.
598.
598. I know. 598 to 599. Yes.
Yeah, yes.
Oh, it's 2 pages you're referring to.
Oh, sorry, I see it. Yes, I apologise. Yes, 598. The bottom of 598, these were the submissions from Counsel Stephen Solly QC and Alan Fraser for Clingham. At the bottom of page 598, even if it is held that the proceedings are properly characterised as civil, defendants are entitled to a fair hearing in accordance with Article 6.1 in determination of his civil rights and obligations. In determining what is fair in this context, an almost or quasi-criminal approach should be adopted not only in relation to standard of proof, but in interpretation of the wider procedural issues. That picks up the point. In circumstances that would include particular need to have regard to minimal requirements. And then there, on page 599, just under letter B, the application of the criminal standard of proof as being likely to be appropriate in the majority of applications for antisocial behaviour was accepted by the Court of Appeal. That is an unsatisfactory approach in relation to the appropriate standard of proof. It would lead to lack of clarity and certainty. The proper interpretation is that the appropriate standard of proof is the criminal standard. It's unrealistic to suggest some sort of sliding scale between the criminal and civil standard of proof. Application of criminal standard of proof would go a long way to achieving a fair trial. And then further, the next paragraph is all about the submissions about hearsay. And then submissions about jurisdiction. The Secretary of State's written case cannot be found. We even contacted the archives about it, but they haven't been able to obtain the documents because they are stored apparently somewhere off-site and don't know if they have them anyway. But the report does not suggest that he was responding to any argument made that Article 6 required a criminal standard of proof, and that's 606H. At the bottom of that page, so the best that can be said in my submission is that it's tangentially raised in a very small way in the written case of Clingham, in circumstances where it's not one of the certified questions in the statements of facts and issues, and dealt with in very summary terms by the respondent to that case. The second point was relating to the judgment itself. In my submission, the judgment does not in any way suggest that anyone was arguing that Article 6.1 required the criminal standard. In Lord Staines's summary at paragraph 4, he sets out that the principle, so that's page 608, the principal, general and common questions are whether as a matter of domestic classification, that's that point, and whether under Article 6 such proceedings involve a criminal charge. Underlying those questions are two specific issues, namely whether under Section 1 of the Act hearsay evidence is admissible, and what the standard of proof is in such proceedings. But he doesn't say, if it's not a criminal charge, whether Article 6.1 requires the criminal standard to apply, which is what you might expect. I realise it's a judgment and not a piece of legislation, but nonetheless, the standard of proof was a real issue because the Court of Appeal in McCann had said that it might vary. And there was obviously a concern expressed in everybody's arguments that that would be wholly unsatisfactory. So the way he wrote that question is to deal with the practicalities of what the Court of Appeal had said.
And perhaps the next sentence is significant as well. The evidential question arises primarily in the Clingham case, and the question as to standard of proof arises mainly in the McCann case, whereas you've shown us that the written cases, I think, in McCann didn't address that at all. It was the other way around.
Yes, it was. And the concern, so you can see why the court felt the guidance on whether there was a sliding standard of proof depending on exactly what was being sought in the ASBO. And this is borne out at paragraph 15.
Was it thought in the arguments on classification of whether this is civil or criminal, was it thought that that would itself determine whether the standard of proof was criminal or civil? Was the case argued on the basis that it would follow the classification?
It doesn't appear to have been put precisely like that.
Well, I thought you showed us at the bottom of 598 that Mr. Solly QC was saying even if the proceedings are properly characterised as civil, nonetheless, because it's quasi-criminal and so on, it's a criminal standard that applies.
I just wondered whether that might be the explanation for why Lord Steyn said that the question as to standard of proof arises mainly in the McCann case, because it was in the McCann case that they were specifically arguing the classification as criminal or civil. But I may be overreading.
It may be just who picked up the baton in actual argument, because both cases were raising, that's why they were joined, were raising.
But it doesn't either seem to deal with it as a question of construing the statutory wording as to what.
But we say that the standard of proof that Lord Steyn was referring to and concerned with was this idea that it wasn't, that it would depend from case to case, and you can see that at paragraph 15 of the judgment.
Well, I think it may be relevant to refer to paragraph 13 as well, because in McCann, as I understand it, the issue about standard of proof really came out of observations by the Recorder of Manchester.
Yes.
About how that issue should be addressed. And it's the Recorder of Manchester saying the standard to be applied is the civil standard, but then he refers to the heightened civil standard. And in the circumstances, he says, for the purposes of this particular case, we will apply the standard being satisfied, so we are sure. So that's the criminal standard. And then Lord Steyn says, this is an important observation by a highly experienced judge, and he's going to come back to that.
Yes.
So it's almost as though the discussion of standard of proof in McCann arises not so much out of argument about Article 6.1, but by way of a commentary on what the Recorder of Manchester had done.
Yes, and in a context where you have this line of case law and the decision in B against Chief Constable, which is referred to in paragraph 13, about the heightened civil standard being, for all intents and purposes, indistinguishable from the criminal standard. And you'll see at paragraph 15, but it's on page 613 at, 613D, the position present, therefore, the position is that in proceedings under Section 1, magistrates have to decide on a case-by-case basis what standard of proof to apply. The Secretary of State has challenged this ruling in the Court of Appeal, this ruling of the Court of Appeal, because they weren't there in the Court of Appeal. Counsel submitted on his behalf that it is preferable to apply a single fixed standard of a balance of probabilities. But that, again, it's framed in the language of of this idea of a heightened civil standard and a tension within the case law. paragraph 37 then, which is the relevant paragraph dealing with the standard of proof after he's addressed classification and the admission of hearsay evidence, so it's page 620. In my submission, where he says that in my submission, he deals firstly with the heightened civil standard would usually be necessary, then looks at practical reasons, which the recorder said had decided to apply the criminal standard. The Court of Appeal said he would usually be right. Lord Bingham has observed they're virtually indistinguishable. I do not disagree with any of these views, but in my view, pragmatism dictates that the task of magistrates should be made the more straightforward by ruling that they must in all cases apply the criminal standard. So it just flows from the domestic non-Article 6 case law about heightened civil standard being indistinguishable from the criminal standard. And when you're giving guidance to the magistrates' court, and he accepted that it would be completely undesirable to have different magistrates applying different standards. And that's his reference to pragmatism and consistency and predictability, which he says at H on page 620. And that this approach has its genesis in the line of common law authority and not in Article 6. So that's what we say about Lord Steyne. And in relation to Lord Hope, in my submission, that it's the same. The main classification, the main question is classification, that he starts on page 621. And he says at paragraph 43, the main question which they raise is the familiar one of classification. If proceedings under section 1 are to be classified as criminal, all the normal rules of evidence which apply to criminal prosecution domestic law must be applied to them. This is of crucial importance to the use with which may be made in these proceedings of hearsay evidence. He agrees most of the judgment deals with classification and reasons for that classification being civil as opposed to criminal. And he concludes at 77 on page 632 that the proceedings are civil for the purposes of Article 6, or rather would be classified as civil. At 78, there was then a question about, well, actually, he concludes that they're not criminal, I think is the fair point to say about 77. At 78, he then goes on to consider whether or not the proceedings were in fact civil at all, because there are certain types of proceedings that fall completely outside the scope of Article 6, and he's prepared to accept, I think that's how he puts it, that they are civil. And then at paragraph 80, he says, although paragraph 80, page 633, letter F, although the jurisprudence of the Strasbourg Court appears to me yet unclear on this point, i.e. as to whether these should be classified as civil at all, I would hold that the fact that prohibitions made is sufficient to attract the right to a fair trial, which is guaranteed by 6.1. This means that the court must act with scrupulous fairness at all stages of proceedings when it is making an assessment of the facts and circumstances that have been put before it in evidence and of the prohibitions, if any, that are to be imposed. It must ensure that the defendant does not suffer any injustice. And then he goes on to deal with the standard of proof. Now, he looks at the standard of proof in the context of paragraphs 82 and 83, and in my submission, none of the cases he relies upon are cases where Article 6 was argued. And in my submission, he's not doing anything other than applying common law standard of fairness as understood at that time, given that there's an ability to have a heightened civil standard of proof.
And I think it might be said paragraph 81 is of some significance there, because again, it starts with the Recorder of Manchester and his comments about the approach to be applied, which was commended by Lord Phillips in the Court of Appeal.
Yes.
And then Lord Hope says, I too would endorse that approach. So, I mean, again, the starting point is what the Recorder of Manchester had said and how that came through.
Yeah. And he was entirely founded on B.
Yes, absolutely.
And the heightened civil standard. So, I mean, we can go through the cases. All the cases that he relies on are in the bundle, but I don't think it's a matter of dispute that they're not Article 6 cases. Now, Article 6 was obviously central to the question of classification in the case, so that's obviously why it's there. But it was also, it arose in two other ways. It was relevant to fairness in the context of hearsay and what the procedural requirements were in relation to hearsay, and relevant, of course, to whether or not the matters fell within civil proceedings at all. So, in my submission, the court was not considering that. Then the third reason was that there's no citation of even the general principle that matters of evidence and admissibility and assessment is a matter for domestic, principally a matter for the national authorities. And even though in fact, Ringwald is new, it postdates McCann. It's predicated on earlier line of case law from the 1980s. And then the final point is that the Court of Appeal, there's no suggestion in the Court of Appeal judgment, which we've put in the supplementary bundle, that this point was being made either. The Secretary of State was not involved in those proceedings, and that's probably because the Human Rights Act actually wasn't in force at the time, I think, because that came into force in October, 1st of October 2000, and I think the Court of Appeal judgment might have been February. But anyway, they weren't. Oh no, they were. It was in force actually. I was wrong about that. But anyway, they weren't involved in the Court of Appeal proceedings. And so, in my submission, it would be surprising in the extreme if their lordships had thought they were holding anything other than that ASBO proceedings are civil proceedings, but that in light of existing domestic case law on heightened civil standards, those heightened civil standards should apply.
Sorry, I didn't catch.
So it would be surprising in the extreme if their lordships had thought they were holding anything other than that ASBO proceedings, Section 1 proceedings, are civil proceedings, but that in light of the existing domestic case law on heightened civil standards, those heightened civil standards should apply.
Thank you.
But that it's easier just to tell magistrates to apply the criminal standard.
Because they know, magistrates, they've got two standards, the civil standard and the criminal standard, and so given that they are indistinguishable, said Lord Bingham in B, it's easier to just tell them to apply the criminal standard. Now, I've had a note from Ms. Mountfield overnight. I had and in broad terms, in my submission, her note on the various paragraph references doesn't actually take the matter any further. And obviously, I disagree with her analysis, and it'll be a matter for you. And there are some new points raised about Osborne, which I haven't had time to digest, to be honest, and I'm perfectly willing to put in a short note in response if you want to hear me on that, but I'm not in a position to just respond to that on the hoof this morning. And Mr. Manning may wish to add.
Yes, we're content to give you time to respond to the particular points about Osborne you wanted to reply to.
Thank you.
Yes, certainly. What would you say, within 14 days?
Yes, thank you. That will be no problem. And those are my submissions unless there are any further issues. Thank you.
Thank you very much, Ms. Watford. Mr. Manning.
My Lord, thank you. Might I just have a moment to shift over?
Of course.
I'm grateful. My Lord, my Lady, I don't intend to address you at length. You'll be relieved to know. And I'm grateful to adopt the submissions of the Secretary of State, both on the status of the Strasbourg jurisprudence in relation to Article 6.1 and standard of proof, without adding any comments of my own. In relation to the question of whether McCann is to be treated as an authority on the requirements of Article 6.1, I don't propose to reiterate anything that my learned friend Ms. Broadfoot has said on that, but there are one or two additional comments that I would like to make, in particular in relation to the fact that McCann has been considered by the Court of Appeal in relation to the very types of behaviour that are confronting this court today, some of which are relied on by my learned friends for the appellants. But in my respectful submission, none of those authorities properly analysed support the proposition that the court in those cases treated McCann as applying any kind of general principle to the standard of proof in antisocial behaviour or gang-type cases, whether on the basis of Article 6 or anything else. My Lord, the first of those, and there are three cases that I propose to go to briefly. The first of those is the Shafi case, which my learned friend Mountfield took the court to yesterday, and which is in the primary authorities. The passage that I've got is at page 685, which is tab 10 if anyone is using the paper volumes. And there is a passage beginning at the at letter H under the heading Public Nuisance. which refers to the fact that the authority, the local authority in that case, were putting its case in relation to the defendants alleged to be involved with gang activity in that case on the basis of public nuisance. And on page 686 in paragraph 38, the Master of the Rolls and Lord Justice Ricks refer to a case of Nottingham City Council and Zane, where the court allowed an appeal from an order striking out an action seeking an injunction restraining a defendant from entering a housing estate. The injunction was sought on the basis of evidence that drug dealing was taking place publicly on the estate, and the defendant was associating there with well-known drug dealers and that he had been arrested on suspicion of drug dealing. The court held that that arguably amounted to a public nuisance, and since the council considered, in terms of the condition precedent in Section 222 of the Local Government Act 1972, that it was expedient for the promotion of the protection of the inhabitants of their area, it was entitled by reason of that section to seek an injunction in its own name restraining commission of the public nuisance, whether or not it was also a criminal offence. And their lordships then, in a series of paragraphs going down to paragraph 42, which I'm not going to read out, refer to the way in which the Court of Appeal in that case dealt with issues of public nuisance. There's a short passage at paragraph 40 in the judgment of Lord Justice Sheeman, where he says it's within the proper sphere of local authorities' activities to try and put an end to all public nuisances in its area, provided that it satisfies the condition precedent of Section 222, and that this has never been the subject of adverse judicial comment. Now, the importance of that is when we get to paragraph 53 on page 690 of the same judgment, where their lordships have already said that courts should, in their discretion, not grant injunctions where the terms sought are identical or almost identical to those of an antisocial behaviour order. And at 53 it says, it makes the point that if the court does consider it appropriate to exceptionally to grant an injunction, the standard of proof set out in McCann should be applied. But then they say, in expressing those views, we do not wish in any way to undermine the general principle adverted to on behalf of the Council, approved in the recent House of Lords cases in D and B, that the standard of proof in civil cases is proof on the balance of probabilities. This will be true of the ordinary case of the kind which Lord Justice Sheeman and Keane had in mind in Zane's case, in which the Council seeks an injunction to restrain a public nuisance. Now, in my respectful submission, although in Zane the argument may have been put in terms of restraining a public nuisance, it's quite clear from the fact set out at paragraph 38 that the conduct complained of was essentially drug dealing, potentially gang-related drug dealing. And in those circumstances, one might have thought that, having referred to McCann at paragraph 53, if the Master of the Rolls and Lord Justice Ricks had thought that McCann mandated a criminal standard of proof for matters of this kind, they would not have given the comment at the end of that paragraph that they did. And they say a similar thing as well at paragraph 65 on page 693. Lord Justice Moore-Bick in Shafi had dissented on the standard of proof. And at paragraph 65, the Master of the Rolls and Lord Justice Ricks comment on that dissent and express the view that they adhere to Lord Staines's reasoning, essentially for narrow pragmatic reasons and for reasons of fairness. The difference between our view and that of Lord Justice Moore-Bick is a very narrow one. Again, they stress that they don't depart from D and B, And then they say, in particular, we recognise that there may be cases in which the relief sought is not identical or almost identical to an ASBO, and where the facts are much more complicated than they are here. In such cases, subject to of course to argument in a particular case, we see no reason why the ordinary civil standard of proof should not apply. Now, again, it's my submission that what one gleans from those passages in the judgment is that the Court of Appeal was of the view that on a very narrow basis, because in the particular case they considered that the remedy sought, or the terms of any order sought, were identical or almost identical to those of an antisocial behaviour order, and they've raised at other points in the judgment what they regarded as an absurdity. I don't need to take the court to it, but paragraphs 51 and 52 of the judgment, where they say, well, what would you do if it was a case involving a person under the age of 18 who would have to be subject to an ASBO and therefore the criminal standard of proof, acting at the same time as a person who was over 18 and could be the subject of a civil injunction to which the civil standard of proof would apply. That was a matter that they regarded as, in my respectful submission, extremely influential in their overall conclusion, that where the remedies were so closely aligned, the criminal standard of proof set out in McCann should apply. But there's no suggestion in this judgment that that's on the basis of a general requirement, either from Article 6 or from anywhere else. It's simply a question that arose as a result of what had happened in that particular case.
I mean, it's perhaps just worth referring also to Lord Justice Smallbick's dissent, paragraph 72, page 695, where he likewise says that the ruling in McCann was essentially for pragmatic reasons.
Yeah, my lord, yes. Yes, we set out quite a long quote from Lord Justice Smallbick in our written case. I didn't want to take up time repeating that, but yes, I gratefully accept my lord's comment. Can I then move to the second of my three cases, which is the case of Swindon Council and Redpath, which is sorry, I've got the page, it's page 2466. And this was a case involving a type of antisocial behaviour injunction that Maloney Friend Ms. Mountfield referred to in passing yesterday, namely arising under the Housing Act 1996. In many ways, it was the predecessor of the 2014 Act. In 2014, Parliament repealed both these provisions in the Housing Act 1996 and the antisocial behaviour provision and combined them together in a civil injunction as set out in that Act. But this was the antisocial behaviour injunction in the county courts at the time. And my Lord will see again that Lord Justice Ricks, who was giving one of those who gave the leading judgment in Shafi, was giving the leading judgment in this case as well. The facts are somewhat different, and the principal issue was somewhat different. It was as to the definition of housing-related conduct. But there is a passage that, in my respectful submission, is instructive. On page 2481, under the heading The ASBO Legislation, paragraph 49, counsel for the defendant, or the appellant, had submitted that Swindon's wider powers as a local authority to police its area for the purpose of obtaining ASBOs, for which purpose it does not have to meet any housing-related conduct condition, makes it unnecessary to strain the boundaries of the narrower ASB legislation. And he then sets out where the ASBO provisions are to be found. And then, just by letter G, some of the principal differences between the ASBO and ASB regimes are as follows. And at little 4, the standard of proof in the obtaining of ASB remains the civil standard, whereas the standard of proof in the case of an ASBO, for the purpose of section 11A, is the criminal standard, referring there to McCann. Now, there are other differences referred to, some of which have been referred to by Maloney Fenris Mountfield, including the age against which an ASBO could be obtained compared with that of an ASB. But it's the standard of proof that's specifically referred to, and at paragraph 50, you court will see that counsel was attempting to pray and aid the court's decision in Shafi. And at B, Lord Justice Rick says, the question in Shafi's case was whether a common law injunction in aid of the criminal law or on the basis of an alleged public nuisance could be obtained by a local authority in circumstances which would entitle the authority to obtain an ASBO, but where the local authority nevertheless sought to avoid the requirements of the ASBO regime, including that of the criminal standard of proof, by moving for a common law injunction. The judge said he had no jurisdiction. The court disagreed, but that as a matter of the principled exercise of discretion, should have left the local authority to its primary statutory remedy of the ASBO, and not indulge in parallel creativity by the extension of general common law principles. I can see no assistance from Mr. Luber in Shafi's case. We're not concerned with an attempt to extend common law principles, but with the question of whether the facts of this case come within the statutory regime of the ASB. On certain facts, it may be that a local authority has a choice between an ASB and an ASBO, and if that is a genuine choice, I do not see why it cannot choose which it prefers. At any rate, so far as jurisdiction is concerned. As for matters of discretion, however, the difference between the regimes may well enter into the argument. However, there's been no attempt here to show that this is a case more properly relevant to the ASBO regime, and Shafi's case did not deny jurisdiction on the grounds of parallel creativity. And so, again, I respectfully submit that had Lord Justice Ricks in that case thought that antisocial behaviour of the kind that it gives rise to these sorts of remedies gave rise to an Article 6 general principle that was set out in McCann as to the need for the criminal standard of proof. It's inconceivable that he would have said that the local authority might, in certain cases, choose to proceed under a remedy for the same kind of behaviour that only attracted the civil standard of proof. And in fact, although Section 1, the 1996 Housing Act, did not specify a standard of proof, it was not suggested that there was anything improper in the civil standard of proof being applied. So again, I submit that in this case, that the clear conclusion must be that McCann was not regarded as laying down a principle derived from Article 6, because that would have meant, in my submission, that the court could not have reached the conclusions that it did at paragraph 51. And the third of the three cases that I referred to is Birmingham City Council and James, which is at 2536. And this is an authority actually in relation to the scheme of the 2009 Act. And the question was whether or not the court had been entitled to make an injunction in the way that it did. And if I can pick it up on page 2543, at paragraph 12, where Lord Justice Moore-Bick was setting out the arguments raised by the appellants, and at just between letter D and E on that page, he says, according to Mr. de Mella, however, The critical difference lies in the standard of proof which must be met in order to obtain the order. In order to grant an ASBO, the court must be satisfied to the criminal standard that the defendant has acted in a antisocial manner, i.e. in a manner that has caused or is likely to cause harassment, alarm or distress to one or more persons of the same household, and McCann is there cited. That higher standard of proof he submitted provides a greater degree of protection to the defendant, and for that reason the court should not grant a gang injunction unless it is satisfied that an ASBO will not achieve the desired outcome. So this was a sort of Shafi type argument that the ASBO ought to be the remedy that the court requires to be used because of the heightened standard of proof. And his lordship says at paragraph 13, for the reasons I've indicated, I do not think an ASBO would necessarily involve a less serious interference with the defendant's personal or private life. That would depend on the terms of the order in each case. It's true that the standard of proof that must be met in order to obtain an ASBO is higher than for a gang injunction, but the facts that must be established are different and less serious than those required to support a gang injunction. It may therefore not be as difficult to prove them even to the higher standard. However, the truth is that the two statutes are directed at rather different social problems. And now, I make 2 points about that. One is that Lord Justice Morbick, in my respectful submission, with great respect, was correct to identify that the standard of proof is, if I can paraphrase him, not the be-all and end-all in terms of whether or not a claimant is likely to be able to prove the matters that must be proved. But secondly, again, in my submission, that analysis is inconsistent with the proposition that where gangs are involved, where this sort of behaviour is involved, there is any general principle derived from McCann to suggest that the criminal standard of proof must be required. My Lord, I don't need to take your Lordships or my Lady to either B or D, unless it would be of assistance. You've seen them already during the course of the hearing. But the only points I would make is that neither of those decisions were predicated on Article 6.1 either. And therefore, the whole of the examination of the case law, in domestic case law in this context, in my submission, is to be seen on the basis that McCann was a decision applying domestic law principles at a time when the common law was understood to give rise to a flexible civil standard, and therefore it was a matter for the court to determine what that standard should be. But not that there was some prior European Convention-based requirement for matters of this kind to attract this criminal standard of proof. And on that point, I again defer to the submissions of my learned friend, Miss Broadfoot. My Lord, those are the submissions I would seek to make on the way that McCann should be seen. May I briefly, and by which I mean in a couple of sentences for each point, just identify some issues of fact that I would seek to correct arising from the learned friend Miss Mountfield's submissions yesterday. Actually, they're not just questions of fact. The first relates to this. As I recall, my Lord Richards asked my learned friend whether there was any question of mens rea arising in proving the fact related to injunctions of this kind. May I just refer the court, without taking your lordships there, to Lord Hope in McCann at paragraph 71 on page 630, where he says that it isn't necessarily the case that conduct in ASBO cases will be criminal, because, for example, under the Public Order Act, it's necessary to prove intent. and under the Protection from Harassment Act, it's necessary to prove that the defendant knew or ought to have known that what he was doing was a course of conduct of harassment, whereas that's not the case in ASBO cases. Likewise, in James, where we've just been, at paragraph 11, on page 2542, Lord Justice Moore-Bick says that it's not helpful to introduce the concept of mens rea into section 34.2 of the 2009 Act. Although the section is clearly directed at deliberate conduct, it's not necessary to import mens rea into that. The second point is on ASBOs. My learned friend made the point that there was no power of arrest under an ASBO, but in my submission that was because by section 1 subsection 10, breach of an ASBO was an arrestable offence, punishable with up to 5 years imprisonment on indictment. So there was no need for a power of arrest. Secondly, in relation to the maximum period of an ASBO, section 1 subsection 7 makes it clear that an ASBO could have a potentially, there was no statutory limit to the period. It could be made until further order. It wasn't a 5-year limit. I think what my learned friend may have meant was that the maximum penalty for breach was 5 years. But these points are all on page 457 and 458. My learned friend relied on the paragraph of Lord Brown's speech in D at paragraph 48, that consequences goes to the standard of proof. I just wanted to make the point that though D was unanimous, that reasoning from Lord Brown was minority reasoning, respectfully. Only Lord Newburger agreed with Lord Brown's speech. Lord Bingham and Scott only agreed with Lord Carswell, who didn't say that. In fact, at paragraph 28, I would submit he said the contrary. And he didn't agree with Lord Brown in his speech either. In relation to the reasons for the standard of proof in criminal behaviour orders, my Lord Stevens, I think, asked about whether there wasn't some pre-legislative materials as to why that criminal standard had been chosen. And just to give the court the reference to that, it's in our written case of paragraph 93 on page 125. And the bill drafter's note to the Joint Committee on Consolidation Bills is at page 3310. And it's really paragraph 306 that sets out that the drafter believed that where breach was a criminal offence, McCann required the standard of proof to be the criminal standard. And then
breach of the order was a criminal.
Breach of the order was a criminal offence.
What was the page number again?
3310. And it's principally paragraph 306 of the drafter's note.
And what point is made?
The point is made that when drafting... So, Section 22 of the 2014 Act prescribed that where after a conviction a criminal behaviour order was made, the matters must be proved to the criminal standard. Those provisions have now been moved to the Sentencing Act 2020. The Sentencing Act 2020 does not prescribe a standard of proof. The bill drafter's note says that that's not because there was any intention to change the standard of proof, but for various technical reasons relating to Consolidation Acts, there was no longer a need to specify the criminal standard of proof. But that the reason the criminal standard of proof had been specified in the 2014 Act and was considered still to be applicable was because the drafter considered that where breach of such an order would be a criminal offence, McCann required the criminal standard of proof to be applied. Now, as my lords and my lady would see if you look at the note, it doesn't give any reasons for that understanding of McCann. We obviously say that that's not a correct understanding of McCann, but it simply sets out why the drafter of the legislation considered the criminal standard to be applicable.
Am I right in thinking from looking at the previous page, this is a note made long afterwards by in the context of the 2020 sentencing consolidation?
It was made in the context of the drafting of the 2020 Act, which, as my lord says, the provisions were moved into.
Because it's a consolidation act and it goes through a different parliamentary procedure.
Yes.
They have to be convinced that it's not actually changing the law.
Yes.
So if you say that the Sentencing Act did not specify the standard of proof, it looked as if it might be different from Section 22, but they're saying, well, it isn't because of McCann.
Yes. Can I raise two very quick questions of fact? The first is that the injunction in the present case made against the appellant in this case did not exclude him from his home. It was suggested, and I don't know to what extent, it was simply the breadth of language that Malone Friend was using, that he'd been excluded from the area in which he lived. But in fact, the exclusion zone in the bundle does not include the home address of the defendant. The map is, I think, at page 185. The injunction itself is at page 181, and it includes an address in Erdington, and the exclusion zone in the particular case does not include that address. I don't have the materials before me, but in other cases where defendants did live within the exclusion zone, provision was made for them to continue to be able to do so. It's just a small point.
And what is the logic behind, what determines this? Is this the area of his alleged gang or the area of the rival gang? Or?
It's the area of both his alleged gang and the rival gang. So, as I understand it, the Get Money gang operated largely on the left-hand side of Handsworth, and the Armed Response gang, which was the rival gang, operated in the other area on the exclusion zone, and the idea was simply to keep the two of them apart. And the final factual matter I would simply raise in relation to my learned friend's arguments about stigma and the justice report that she relied on. I'd just make the point that the reports that are in the bundle talk about stigma derived from the gang matrix that was applied by the Metropolitan Police, not proceedings of this nature. It's a very small point, but just for the sake of accuracy, I wanted to mention it. My lords, unless there are any further questions.
I think not.
Those are my submissions on behalf of the local authority.
Thank you very much, Mr. Manning. Ms. Mountfield.
I start before lunch with Mr. Manning's points, and then briefly after lunch with Broadfoot's points. The correction of fact on the area of the injunction, Mr. Manning's quite right. It was the area where his family lived, his original family home, so I'm sorry if I misstated that. The issue about why the bill draft in relation to the 2020 Act believed the criminal standard of proof needed to be applied to a criminal prevention order, well, that may be what the drafter thought, but it's not the reasoning in the McCann case itself about why the criminal standard of proof, in the view of Lord Hope and Lord Stain, should be applied as a matter of fairness. That's a broader test to which I will return. And in relation to mens rea, it is right that in relation to ASBOs, Lord Hope in McCann at paragraph 71 took the view that there might be he didn't decide the point, but there might be circumstances where the facts alleged in relation to an ASBO were less than a criminal offence. But it is my submission that if one looks at the elements, the elements to be proved for the first condition for the making of a gangs injunction under the 2009 Act, at least, those prohibitions properly are understood are all of criminal acts, because one cannot engage, because violence and drug dealing are criminal offences. One cannot engage in something without a mental element. It involves participation in some way. And the accessory offences, which are specifically named in the Section 34 of the 2009 Act, encouraging and assisting, do both require a mental element, which is set out now in the relevant provisions of the Criminal Justice Act, which are in the the Serious Crime Act, the Serious Crime Act, which are set out in the supplementary bundle. And it's just, well, the relevant provisions of the Act are in the supplementary bundle. Starting from page 86.
Section 44.
Yes, or 44 if you're looking at the Archbold version.
No, section 44.
Section 44 and following, yes. And if that were otherwise, if merely being there when someone did something gang-related and unlawful were enough, it would become a kind of civil pre-Joji joint enterprise, which would not be appropriate given the language used in the statute and the observations of the Supreme Court in Joji.
So why do you read across section 44 into the 2009 Act?
Because, my lord, the concepts of encouraging and assisting a crime are themselves criminal. They're accessory crimes by virtue of sections 44 and following of the Serious Crime Act, and they do require some intent, some mental element, and you can see that in the analysis or the summary of the case law in Archbold. I've now got a different version, which is. I have a different version of my supplementary bundle now.
It's clear on the face.
3385 is from memory. 3387, page 37 of the supplementary bundle and following.
I'm sorry, what was the page? Did you just say?
Page 37.
Thank you.
Sorry, my lord.
The mental element is there in section 44.
Yes. Offence of intentionally encouraging or assisting an offence.
And intending.
Yes.
But not simply because it was a foreseeable consequence of his act.
Yes.
And so what is your submission in relation to how that maps on to section 34 of the 2009 Act?
My submission, my lady, is that the Serious Crime Act was enforced when the 2009 Act was passed, and so the concept of encouraging or assisting a crime was to be treated in the same way and therefore requiring a mental element. So the purpose was to provide civil assistance in upholding. The purpose of the 2009 Act was to provide a civil remedy to provide assistance in preventing breaches or preventing behaviour which breach of criminal law standards, but to permit in a wider.
So you're saying basically that by using the encouraging and assisting words in 2009, they were importing the requirement for the same mens rea as required for Section 44 in the Serious Crime Act.
Yes, my lady. Given the context, it's difficult to see why they would not have been doing that.
Well, I mean, Section 44 is setting out a criminal offence, and it's even described as intentionally encouraging. And Section 34(2) is just using ordinary language in a civil context. I mean, speaking of myself, I don't see why one would read across Section 44 into Section 34(2).
There are also the lesser offences in Sections 45 and 46 of encouraging or assisting offence, believing it will be committed.
Right, but why does one even read across from provisions which are defining specific criminal offences to Section 34(2), which is setting out preconditions for a civil order to be made?
Well, my lord, just because if one looks for a definition somewhere, one has to ask, well, if you took away any form of assistance from any other legislation, what would you mean by encouraging or assisting something? And if you encourage someone, it's a matter of logic. It has a state of mind attached to it.
But that carve out,
that meaning you persuade them in one direction or another, and assistance means help, and helping someone means. I gave the example yesterday. Suppose one of his court were to drive a child, a relative, to school, and then discover the child had cannabis in their pocket. You wouldn't be assisting them dealing in that cannabis at school unless you knew and you thought, I'll give them a lift.
What about the participation in the video? I mean, that was relied upon just as one of the matters justifying the order and the injunction. And then the injunction, if I remember correctly, forbids him from taking part in similar videos.
Which he knows or reasonably to know would have that effect.
Now, but the participation in the video isn't a criminal offence, is it?
No, my lord, it's not. But the learned judge concluded from the context in which he participated in that video that he knew he was helping people who were wearing the Get Money Gang shirts and so on in inciting or encouraging violence, and the primary motivation of those making the video was money. He said, well, I was there because they were wanting to put their video on YouTube, but there was another motivation, which was to threaten violence, and he knew that.
So that's an example, isn't it, of encouraging gang-related violence without committing a criminal offence?
Well, to the extent that was encouraging violence, it was technically an inchoate offence, because the threat of violence is itself an offence.
But the carve-out in 44(2), page 86 of the supplementary bundle, to say that is part of the requirement in Condition 1 in Section 34, I think would be quite a serious matter. Because the injunction, as my Lord President has said, was that you ought to have known that it encourages, but that ought to have known seems to be ruled out for the criminal offence by Section 44(2). No. But if what was proved when seeking a gang injunction was that somebody took part in a video and they ought to have known that that was going to encourage and assist. Do you say that that's not enough for the grant of a gang injunction?
Well, my lady, I want to reserve the position in future cases on that.
Right.
Because I can see that it could well be argued that by using that language, which reflects the language of a criminal statute, that higher standard should be imported in. But even if it isn't, then the but even if it were required, sorry, I'm gone off my stride now. I can see the argument that it should be, but even if it were not, then the point I'm making is that this is not like civil nuisance. This is quasi-criminal behaviour. It's very close to that. And I'm asked to point out, and it's a good point by my learned junior, Mr. Stark, it's on page 232 of the bundle, at paragraph 224. Her Honour Judge Wall did not find that the participation in the video amounted to encouraging and assisting. She used it as evidence of gang affiliation. There was only one finding of behaviour falling within section 6.
So I'm thinking in a different case.
So that's quite right. So that in this case, she wasn't making a finding one way or the other on that.
But your submission, your general submission, which is that this is criminal or quasi-criminal submission, doesn't depend, I wouldn't have thought, on you establishing that in every instance where condition 1 is satisfied, a criminal offence will have been committed.
No, my lady, it doesn't. You're right, and it's a different point from the point that was in Swindon and Redpath, because that was about the difference between a nuisance-related injunction and something that causes annoyance or nuisance. Certainly it might not be a criminal offence, but it may be something that can be the subject of injunction either from a housing provider under the ASB legislation as it then stood, now under section 2(1)(b) or C of the 2014 Act, or at the suit of a private individual who suffered nuisance or annoyance as a tort. So that's a very different circumstance. We're looking at this quasi-criminal behaviour, and that's why in relation to the 2014 Act, the declaration is only sought in relation to section 1(2) of that Act, insofar as it relates to behaviour under section 2(1)(a), which is the ASBO-like behaviour.
Just wondering why, whether reading across section 44 would undermine the protective element of the section 34 of the 2009 Act, insofar as if someone unwittingly was actually physically present and thereby encouraged. For an order to be made, he has to actually intend to encourage or assist his commission. I mean, take an example. You could have somebody who was physically present when somebody else was extolling the virtues of gang violence.
Yes.
And unwittingly, he didn't want to, but in order to protect him, you would like to remove him from that type of situation.
Well, my lord, that's the point, that you might want to protect him by giving him a mentor or telling him to keep out of the way, but do you protect him by saying, never mind what you did or didn't intend, but if you're ever in that situation again and we catch you, you can be sent to youth detention for 3 months. That's the point, that this is quite serious. The consequences of these orders are serious ones. So yes, these may be things from which one would wish to protect young people, and it's indeed in the 2012 white paper that this isn't meant to be the only thing you do. There are all sorts of other ways you can try to put people on the right path, and they're not necessarily all through the criminal justice system or injunctions in support of the criminal justice system in general. There are other ways of seeking to help people, as for example the mentoring scheme that Mr. Jones was participating in at the point of these events, Mr. Robinson.
Now, it's
I won't
well
be very long,
past.
I hope, after lunch.
Yes, well past 1 o'clock. So when we resume, we'll try to exercise some self-discipline and give you a clear run to finish your submissions in the time you have available.
Yes.
In the meantime, we'll adjourn.